Hi everyone, thanks for joining. Good to have so many of you on again today. And thank you once again to Fiona and Emma for taking time out of their busy diaries to do another webinar for us. Once again, we've had a really good response, and it seems that COVID continues to wreak havoc in all of our lives, whether it's from a personal or a work perspective. And one of the areas it seems to be having a bit of an issue is on diversity and inclusion. So again, Fiona and Emma sort of highlighted to us that this is a key area where they seem to be getting lots of questions and queries. So hopefully this will be very useful to you all, and I will hand over to both Emma and Fiona now.
Thanks very much, Verinda. So just to start off with some housekeeping for you all. If you lose us, please click the link on the invitation you've received, and that should bring you straight back in. And if you have any questions, we'll be having a Q&A at the end, but obviously feel free to ask any questions as we go along, just using the speech bubble at the bottom of your screen. And we're going to try and answer as many as possible throughout or at the end of the webinar. So in terms of today, if you've attended previous sessions that Emma and I have run, we're both solicitors in the employment team at Freeths, and today we're focusing on diversity and inclusion, as Verinda has said, and some of the impacts that we're seeing from remote working particularly. If we go on to the next slide, which sets out today's discussion, we're looking at rights and responsibilities in a respectful and professional environment, anti-harassment policies and procedures, freedom of expression and online harassment, some practical hints and tips. We wanted to do a quick roundup of COVID because it sparked so much interest at the last seminar. There were so many questions, and obviously it's continuing to be it's an ongoing situation as we find out more about the vaccination, the immunity around vaccination. So I wanted to do a bit of an update on that. And then we're going to spend the rest of the time answering your questions. So as I say, please do send any questions in using that chat function. So if we move on to the next slide, we wanted to look at, why is diversity and inclusion training important now more than ever? And remote working has had an impact. Our employees are away from the office. We can't necessarily see, everybody's under a lot more stress, what's going on with them. There are a lot of virtual platforms. There's a lot more social media engagement. So whether it could be in either one-to-one meetings or larger Zoom calls, there are other opportunities and more online opportunities for harassment to occur. There's also greater risk of comments being misinterpreted or offence taken. And I think also there's greater awareness at this time. Last year we had Me Too, and lots of awareness raised about how harassment can take place across all sectors. There was a government paper issued off the back of that. We've seen last week with the tragic case of Sarah Everard and all the media surrounding that, the increased focus on harassment of women. And then we've also had recently some key cases from the employment tribunals, where tribunals have looked at harassment cases. They've looked at what employers are doing in the workplace, and they've said, actually, you've not been doing enough to protect your employees from harassment. And there were a couple of surveys undertaken last year, one by the legal charity Rights of Women, and it said nearly a quarter of women in the UK who have faced work-based sexual harassment said it had increased online during the COVID pandemic. 42% of respondents had recently experienced harassment from co-workers, and 70% thought their employers were not doing enough to protect them, which I think that figure of 70% is really quite significant. I suppose other considerations are as well that for those who are back in the workplace, they are socially distanced. There's limited numbers in the workplace, so there aren't as many bystanders who are there to witness any inappropriate behaviour or challenge any inappropriate behaviour. And it's difficult economic times too. So there's also issues in terms of employees are less likely to report issues because they might fear losing their job, or they fear that they're seen as a troublemaker. So there's lots of issues that are arising from the current situation we find in the workplace, the impacts on diversity and inclusion. And we know harassment can take many forms. It could be from colleagues or clients and customers, on social media. It can be jokes, it can be banter or messages, pictures or stalking. And it can also be directed at both men and women. And we're certainly seeing as well research showing that people from sexual minority groups experience increased levels of harassment. So I know in the claims that I'm dealing with at the minute, I've definitely seen an increase in claims alleging discrimination or harassment on the grounds of sexual orientation. So there is that increased risk, and it's certainly going to have an impact on business, not least, obviously, the effect it can have on staff and their ability to work and be productive, but also it has a broader detrimental workplace impact, low morale, high turnover, and also, the risk of costly tribunal cases and the impact on reputation. And the key reason for this is an employer can be vicariously liable for the actions and conduct of its employees during employment. So if you have got an employee in the workplace who harasses another, because that is during the course of employment, then the employee who is subject to the harassment may well bring their claim against the company as the employer. Now, the employer would be liable for that, even if they didn't know or approve of those acts. However, there is a defence open to employers, which is known as the reasonable steps defence. And an employer can rely on this if it can show that it's taken all reasonable steps to prevent that discrimination or harassment occurring. And that means having in place an equal opportunities policy, it means taking relevant action, it means training your staff. But it's not enough just to have those things in place and tick that box. It's got to be more than that. You've got to refresh your training. You've got to make sure staff are aware of acceptable and not acceptable behaviour. And we've had a recent case which really illustrates how you do have to go further than ticking that box, that you do need to refresh your training and make sure that it's up to date. And that was the case of Ale and Gielen, which is on the next slide. And in this case, the diversity and equality training was said to have effectively gone stale. And so the employer in that situation could not rely on that as a defence to say they'd taken all reasonable steps. Yes, they had a policy in place. Yes, they trained their staff, but it clearly wasn't effective and it wasn't sufficient. And in this case, Mr. Gielen had been harassed by a colleague on the grounds of race. There was an investigation by the employer. It was found that the individual concerned had made regular racist comments, and further equality and diversity training was organised. Mr. Gielen brought a claim in the employment tribunal, and the tribunal upheld the complaint, concluding that Mr. Gielen's colleague had regularly made comments about how he should work in a corner shop, that he had brown skin, and questioned why he was in this country. And I think one of the key issues in this case was that there was one colleague and two managers who were aware of the racist comments but took no action other than a mild rebuke of the individual who had made them. And the tribunal therefore said, you cannot rely on the reasonable steps defence in this situation. Yes, you have an equal opportunities policy and a harassment policy, but clearly that's not effective because you've got somebody making these comments in a workplace and you've got two managers and another employee standing by and not taking any sort of action. So the employer in that instance was unable to rely on the reasonable steps defence. So ultimately what the tribunal will look at is, well, are there any other steps the employer could have taken? And in this case, they could have taken other steps. They could have updated their training. The training in this instance hadn't been done for several years, a year and 8 months before Mr. Gielen had joined the company and 2 years and 8 months before his dismissal. The AT said, you've got to look at the nature of the training and the extent to which it is likely to be effective. So I think that is an indication that tribunals will look at your policies, at your training, whether it is sufficient and whether it is effective. So that's the bar that you've got to hold up to, that if you were to rely on this defence in an instance where a claim for harassment or discrimination were brought, are you happy that you have taken all steps that you need to, that the training is effective to address these sorts of issues? And the EAT did say in this particular case that the policies and the training didn't appear to be impressive, even for a relatively small employer. And of course, we know the larger the employer, of course, there's going to be a higher expectation. But even if you are a small employer, there is still an expectation that you need to be addressing this area. So comprehensive and effective training is really key. The judge said, and I've put this on the next slide, the quote, but it's not sufficient merely to ask whether there's been training. Consideration has to be given to the nature of the training and the extent to which it's effective. If it's a case of just gathering everyone together and saying, here's your harassment training, don't harass people, now everyone back to work, that's unlikely to be effective. So do think about that. The culture of the organisation is also important. Do your managers know how to deal with harassment and discrimination when they witness it or they're told about it? Do you need to think about bystander training so that people know what action they need to take? Does your harassment policy include banter? In this particular case, the manager believed he was having racial banter with the claimant. Well, that amounts to harassment, but clearly he didn't see that line being drawn. And I think the case really shows as well that you need to undertake an annual review of your training, of your policies, to make sure that it isn't becoming stale as it did in the Geelan case. So that case, I think, came out last month, but really interesting and clearly a very clear steer for employers and HR departments to look at this area and really make sure that you are up to date on it. If we go on to the next slide, I've just set out some rights and responsibilities that we need to think about in terms of a respectful and professional work environment. And workplace diversity is so important now for all organisations. It increases your talent pool, it brings new ideas and perspectives and skills to your workplace. So that's part of it. Employers also have a duty of care to protect staff, which we've talked about. I think it's really important for employers to be responsible for identifying and managing the risk of harassment claims at work. We've also seen as well that there is an increase in whistleblowing claims, and discrimination or harassment, you could see an individual saying, well, there's breach of a legal obligation there, or there's and therefore raising a whistleblowing claim on the back of that. And we've certainly seen an increase in whistleblowing claims as well. So be aware of that angle as well that can be brought in. It's really important that policies that you have in place in relation to harassment set out what the organisation's responsibilities and then what are the responsibilities of those in the workforce, so that those in the workforce are aware of what their behaviour, the standards of behaviour that are accepted, and to raise awareness. And there are going to be situations in work, we see it all the time, where people don't see eye to eye, but it's about employees understanding how to address those issues in a respectful and professional way, and also where individuals aren't disregarded, because whether there are displays of disrespectful or degrading behaviour, clearly that doesn't help any sort of workplace culture, but also overlooking someone could be seen as potentially excluding or harassing and or discriminating. And we often do see cases now, and I've got a few cases on at the minute, where there isn't an overt type of discrimination, but the individual has inferred that there's discrimination on the grounds of a protected characteristic because they're being treated in a certain way and there's no other explanation for it. I think in terms of, responsibility for having that respectful and professional environment, it's very much on the culture of the workplace as well. It has to be something that's brought in from the very top up, and really embraced by the organisation. And not only does it ensure that you have a great place to work, that you minimise the risk of any claims of this type of nature, but it also has the added benefit of reducing workplace stress, resolving issues and problems, increasing productivity, resolving turnover. So there's lots that can be gained from a diverse workforce, and having the relevant policies and practices in place to embrace it. The final thing that I just wanted to touch upon, which is on my last slide, is about anti-harassment policies and procedures, and how we go about preventing harassment in the workplace. Clearly, prevention is better than cure, and I think having your policies in place, your training in place is a great start. Having a raised profile of HR, having staff surveys so that you know what's going on within the workplace is also great. Remember, harassment in law is defined quite widely. It's unwanted conduct which relates to a relevant protected characteristic and which has the purpose or effect of violating an individual's dignity or creating an offensive environment for that individual. It can be a one-off incident. The victim doesn't need to have made the perpetrator aware that the conduct was unwanted, and it doesn't look at the intention of the perpetrator. The perpetrator may not have intended it to amount to harassment. It ultimately looks at, the effects on the victim and whether they felt they were being violated or whether they felt that it was offensive. And the tribunal has to consider whether that's reasonable, but it's very, very much looked at from the perception of the victim. So think about that broad definition. Your policies, I think it's really important to include what type of work examples could amount to harassment, offensive jokes, rude comments, gossip, wolf whistles. We know the overt ones, but I think setting out really what our expectations are and what behaviour could amount to harassment is really important. Remember that as an employer, you can be held responsible for the acts of your employees, even when you don't have knowledge of them, you haven't approved them, but you do want to make sure that you can rely on this reasonable steps defence so that you can show that you've done everything you can, and you have a robust policy in place. And that policy, of course, should set out both the obligations of employer and employee, what is and is not acceptable. It should obviously set out that any sort of harassment is prohibited. It should outline the reporting procedure for complaints, the procedure that should be undertaken after complaints are raised, and also prohibits any retaliation for any complaints raised. Think about, does your policy cover online harassment? Given the change in nature and what we're seeing with more remote working, make sure that it covers all those types of harassment. And again, think about the culture of your organisation and the training. And when we do become aware of inappropriate behaviour, of course, the next part of that reasonable steps defence is making sure that you take relevant action. So do ascertain as much information as possible from any complainant, try and get it in writing if you can, reassure the individual. It may well have been very difficult for them to have come forward with any sort of complaint of this nature. They'll be worried that they're not going to be taken seriously. So the employer's role in reassuring that individual and informing them about the process that will follow, that everything is confidential. Also ascertaining what they want as a remedy. How can we solve this? Ultimately, that will be part of the organisation's decision as it investigates this, but getting a steer on that can be helpful. And then turning your mind to the investigation that you need to do, who you need to interview as witnesses, what documents you need, and then also considering how you conduct that investigation, whether there is somebody who should be involved in that who's neutral, objective. So there's lots of considerations then in terms of how you approach that investigation as well, which may well all have an impact and needs to be handled very carefully and sensitively, particularly to reduce the likelihood of any sort of claim. And finally, I was just going to flag that there are codes of conduct, which I think can be really helpful in this area. There was a code of conduct published by the government last year in relation to sexual harassment at work. The ECHR code is also really good on this area in terms of giving you ideas. But think about that training and the awareness raising, the staff support, the board commitment, and think about making sure you have those clear reporting methods and that there are appropriate responses to concerns and allegations that are raised. That was all I was going to cover in my section, and I shall now hand over to Emma, who's going to look at another key case in this area.
Thank you, Fiona. Yes, I'm going to be touching on the Taylor and Jaguar Land Rover case. It's a really important case, I think, because not only does it highlight the potential consequences if as a business you get this wrong, but it also shines a light on larger organisations, those businesses that you would expect would have very clear policies in place, larger HR teams, and to show ultimately what can happen when it does go wrong, and the kind of criticism that was levelled at them by the tribunal. So many employers who find that they have a gender fluid or a transitioning employee may not have had to navigate this before. Certainly, I imagine there are a number of you who are experienced HR professionals who have not and perhaps will not come across this in the whole of your career. But I think it is really important that employers know what actions they need to take to ensure that they are supporting any employees that are going through this transitioning process, as well as ensuring that the wider workforce understand what is and is not appropriate to ensure that costly discrimination claims are brought. So like I've mentioned on the slide there, this case involved Miss Taylor, who was employed by Jaguar Land Rover as an engineer. She subsequently identified as gender fluid, and over a period of time had various work colleagues and contractors subjecting her to various instances of bullying and harassment, name calling, offensive jokes, making comments such as, "Is this for Halloween?" or "You have cracking legs." Now, Miss Taylor raised complaints on numerous occasions to the HR team, but neither HR or the management provided her with any kind of meaningful support. And ultimately, she pursued a claim in the Employment Tribunal for direct discrimination, harassment and victimisation on the grounds of gender reassignment. So the first issue for the tribunal to consider in this case was whether gender identity is protected under the Equality Act. Now, the court recognises that the rights of individuals with complex gender identities are protected under the Equality Act, and this states, a person has a protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone a process or part of a process for the purpose of reassigning the person's sex by changing their physiological or other attributes of sex. Now, in this particular case, Miss Taylor wasn't planning to have surgery, but nevertheless, the tribunal said that she was clearly on a journey of transition, and the judgment recognises that the rights of individuals with complex gender identities, so those who identify as non-gender, genderqueer or agender, are protected under the Equality Act. So given that initial assessment had been found in Miss Taylor's favour, ultimately the tribunal found the discrimination claims to be upheld also, and they were very, very critical of the HR function and the wholesale failure it discovered at Jaguar Land Rover to address LGBT issues in the workplace or to specifically support Miss Taylor as an individual. And it found that although the company had policies and agreements in place, which you would expect for an organisation of that size, its culture was not aligned with these. And the tribunal went on to note that this is a systematic failure and demonstrates that the respondent values its employees' ability to perform their key roles far more than their personal welfare or well-being. Now, that's a really damning indictment of a workplace culture, one which values employees getting on and doing their jobs as opposed to them supporting their welfare and their well-being. And a massive organisation like Jaguar Land Rover, which was referred to on numerous occasions, the fact that they are such a large organisation, this clearly was a really big failure on their part, and one which was played out really publicly. It was reported in all of the kind of main newspapers and on various news websites, and ultimately led to them having an award against them to pay Miss Taylor £180,000 compensation. So in terms of what we can take from the case, First of all, we need to be looking at policies, as Fiona's mentioned. Not only do we need a equal opportunities and dignity at work policy, vitally, and what we can take from this case is we need to be making sure that we're implementing this. We need to be able to show that staff have been trained in these issues and that they understand what their obligations and responsibilities are. I think one of the key things I took from International Women's Day last week and all of the various social media postings that kind of went alongside that was this concept of choosing to challenge. And I think that's really relevant here. If the discriminatory comments and the jokes had been called out sooner and action had been taken at an earlier point, the decision, or at least the very high compensation award, may have been significantly different. Secondly, we need to be looking at a positive approach. One of the key issues, again, that Jaguar Land Rover were criticised for was the fact that they wanted Miss Taylor to name the employees who had made the offensive comments before they would take action. And the tribunal made it very clear that employers must take positive action to inform staff and contractors what is acceptable behaviour in the workplace and the consequences of them not complying. And ultimately, everybody who is on site and who is working needs to understand what is acceptable behaviour and what is not. And then finally, this adverse publicity and the far-reaching consequences of it. Like I said, it was reported everywhere, but it has ongoing implications as well. So it may affect your business's ability to recruit. So if employees are looking at you as a business and the first thing they type into Google is a case such as this that's coming up, it's not going to instill confidence in them that this is going to be a business that looks after its employees. Likewise, from a kind of current employee perspective, there may be morale issues. So if employees don't believe that their concerns and their complaints are going to be taken seriously, then you're going to end up in that systematic circle of not wanting to raise complaints because they're not going to be listened to, and the culture ultimately never changing. So in terms of kind of what you can do about that, again, it's looking at whether it's appropriate to look at diversity and inclusion champions. And in this particular case, the tribunal actually, one of the findings and one of the determinations that they made was that Jaguar Land Rover was required to appoint such an individual to make investigations across the business and to report on statistics annually and publicly. And the tribunal in this case also required the judgment to be read out at a board of directors meeting, again, kind of bringing home the seriousness of this and the fact that it needs to be taken seriously from the top. We recently undertook, when the judgment first came out a couple of months ago, undertook a webinar with Robin White, who was the barrister in this particular case who represented Miss Taylor. And she herself is somebody who has been through a gender transition journey. And one of the questions that she was asked by one of the delegates at that was, what can employers do to make sure they can best support individuals who are transitioning or who are gender fluid? Because like I mentioned at the beginning, it is something that may not have ever come up before, and HR or managers may feel nervous or reluctant to kind of have that approach. And Robin's answer to that was very simple, in that simply ask. Everybody's journey is different, and when asking an employee about what can be done to help them, asking that question and having that discussion from an early stage is always going to be a good starting point. And I think it makes you think that actually if they'd have had that discussion in the Taylor case, then this may have had a different outcome. So if we can move on to the next slide. I am moving on to freedom of expression and online harassment. And like Fiona mentioned earlier, this is something that may be becoming more and more relevant. there's obviously an ongoing rise with the use of social media, which we've seen in the last couple of years. But also alongside that, now that we have an increased number of employees who are working from home remotely, and with there being perhaps a long-term shift to remote working, at least a kind of hybrid model perhaps, it may be that employers need to be turning their mind to online harassment a little bit more, because this may be where we're seeing the focus of complaints moving forward. Now, social media or internet misuse can amount to misconduct, which could potentially be a fair reason for dismissal, even if it is done outside of the workplace. The key issue really for employers to consider when they are looking at online harassment and whether it is necessary to take disciplinary action is to consider whether or not the employee's misconduct goes to the employment relationship or it affects their ability to do their job. And that's the kind of key areas that you need to keep focused in mind, because it is a very balanced act of what an individual does outside of the workplace compared to actually, well, what effect does it have on the business? And one of the main cases that explores the concept of online harassment, it's a couple of years old now, but I think the key aspects of it still ring true. Is the Northern Ireland Industrial Tribunal case, which again, although it's a Northern Ireland case, I think the commentary still stands good for UK law. And it was the case of Teggett and Teletech UK Limited. Now, in this case, Mr. Teggett was employed as the customer services representative, and he posted an obscene comment about the promiscuity of a female colleague, A, on his Facebook page. Now, that was done outside of work hours and it was done while he was at home. But the comment mentioned Teletech, and it was read by numerous work colleagues who he was Facebook friends with. Now, A was excluded from this page and didn't actually see it, but became aware of it. And when she sought to get him to remove it, he then posted a further lewd comment about A on his Facebook page. Now, the business became aware of this, ultimately went through a disciplinary process with him to discuss alleged gross misconduct for harassment of a fellow employee and for bringing the company into disrepute by naming it in connection with the comments he'd made on his Facebook page. Now, Teletech's disciplinary policy, code of conduct and dignity at work policies prohibited harassment and unwelcome sexual behaviour, and specifically provided that misconduct in these areas could result in summary dismissal. And ultimately, his employment was terminated on the grounds of gross misconduct, and his subsequent appeal was unsuccessful. He then complained to the Northern Ireland Industrial Tribunal that he had been unfairly dismissed and that his rights under Article 8, which is right to a private life, Article 9, which is freedom of belief, and Article 10, which is freedom of expression, he alleged that they had all been violated by him being dismissed by the company for the reasons that it had. Now, in this case, the tribunal looked at the reasoning and ultimately held that the decision was fair. They said that although they didn't accept that the comments brought the employer's reputation into serious disrepute, there had been harassment of a colleague that was in breach of their policies, and it was sufficiently serious on its own to justify his dismissal for gross misconduct. And that was even though it was done outside of working hours on his home computer. The tribunal also rejected his arguments under the European Convention of Human Rights. They said that when he made his comments public on his Facebook page, he had abandoned any right to them being private. The freedom of belief referred to in Article 9 didn't extend to a belief of somebody's promiscuity. And then finally, the right to freedom of expression, as set out in Article 10, must be exercised responsibly and did not entitle the employee to damage the colleague's reputation and to cause her to suffer harassment. So although this is a relatively serious example of online harassment occurring outside of the workplace, I think we can take from it some some key kind of focus points, and it is worth remembering that ultimately it may potentially be fair to dismiss somebody on the back of such online harassment. So we have said there about, on the slide there, about balancing freedom of expression versus discriminatory behaviour, and I'm sure you will all be aware in the last couple of years we've seen a number of cases where there has been real conflict between the protected characteristic of religion and belief against the protected characteristic of sexual orientation, where some religious groups hold very strong views on homosexuality. And the relevant case law in recent years has suggested that whilst employers should not discriminate against employees because they hold certain religious beliefs, that doesn't necessarily give employees carte blanche to manifest those beliefs, regardless on the impact of others. And very recently, we've seen the case of Page, Lord Chancellor and Secretary of State for Justice, which was an employment appeal tribunal, which held that a Christian magistrate who was removed after he spoke to the press about his views on same-sex couple adoption was not victimised for having alleged religious discrimination. Rather, he was dismissed for speaking to the press against judicial guidance and flouting his judicial oath of impartiality and potentially bringing the judiciary into disrepute. And the same findings were found in respect of his dismissal, in respect of his non-exec director position within NHS Trust. Ultimately, the decision to dismiss was based on the fact that he kept talking to the press, even though they had explicitly told him not to. So it's really just about making sure that you are aware of any potential issues such as that in the workplace and making sure that you balance those very carefully. So in terms of what can a business do to protect, to reduce the risks in respect of claims relating to social media and online harassment, as well as protecting its staff? Well, firstly, I think it's a really good idea for businesses to set out expectations of employees, use of social media by adopting a social media policy or including one in your staff handbook. And appropriate restrictions may cover restricting use of company IT resources, explicitly prohibiting harassment or bullying of other employees or any other discriminatory remarks, and prohibiting the use of negative comments about the company, its employees, business contacts or competitors. It's also a really good idea to make sure that any social media policy that you have is consistent with any other policies. So, for example, your equality policies, disciplinary policies, IT policies, make sure that they are cross-referring to each other where appropriate. And also have a look at your training. So do your courses currently include anything about social media or online harassment? If not, is it worth having a look to see whether they need to be refreshed and updated? So if I can move on to the next slide. So in terms of kind of practical hints and tips for ensuring compliance in this area, like we've seen, respect is a really important contributor to forming positive work culture. So what can be done to ensure compliance in this area? Firstly, to make your business a great place to work, but also to reduce the risk of costly claims against the business. Well, I've said it, Fiona said it, I'll say it again, make sure you develop a really effective anti-harassment policy. So make sure that online harassment is dealt with in any other policies and procedures, so particularly IT policies, for example, social media policies. And ensure that these policies are clear that employees' actions outside of work could potentially impact on their employment and could potentially amount to misconduct. From a cultural perspective, ensure that you're engaging with staff and have an open door policy to ensure that staff feel comfortable talking to their colleagues about any areas of concern. Perhaps it's appropriate to develop some kind of mentoring system so that senior managers are aware of issues that are happening on the ground to try and help tackle systematic culture issues within an organisation. Have a look at risk assessing what's going on in your business. So assess and mitigate the risks in the workplace. is there a culture of banter, which for HR and employment lawyers, that's like a swear word to us. We don't like the word banter. And very often these types of things do end up in claims. So is there a culture of that? Is there a culture of inappropriate comments? I mentioned earlier the kind of choosing to challenge takeaway that I thought was particularly helpful from the International Women's Day social media posts. You want a culture where employees are being pulled up on discriminatory and harassing comments, and that they are being challenged about that. And that can only really happen if there is a cultural shift towards intolerance of that type of behaviour, and that senior managers support HR in driving those changes forward. So look to the board for ED&I champions to get this off the ground and kind of moving it forward. Consider whether it's appropriate to use a reporting system that allows workers to raise an issue anonymously. Quite often this is one of the main reasons why victims of harassment don't come forward. If there is a way that an employee can raise a concern anonymously, you may find that you're having more individuals come forward and talk about their experiences more openly. Train staff on what harassment and discrimination in the workplace looks like. So what to do if workers experience it and how to handle complaints. Make sure your staff receive briefings and trainings to prevent instances of harassment being overlooked. Look at separate training for managers. I'm sure most of you do this already, but they need a kind of higher level of training so that they can handle difficult conversations. They can spot when harassment is occurring, and likewise look at perhaps whether workshop-based training where employees can participate in scenarios is going to be more appropriate. Sometimes that has more effect than simply sitting down in front of a kind of pre-recorded training video. And as Fiona mentioned, make sure the training is ongoing because it can go stale. You can get yourselves into all sorts of problems if a tribunal claim is raised and it is found that your training has gone stale. Look at whether, look at the timeframes for investigating a complaint of harassment. Make sure that they're being dealt with timely, and that they should be dealt with by using positive action, like I said in the kind of Jaguar Land Rover case, making sure that we're driving forward what is the expected standards within the business. Now, I've talked about positive action on the slide there, and positive action in the workplace is where an organisation treats someone with a protected characteristic more favourably than somebody that doesn't have that protected characteristic. Now, positive action is about ensuring equality of opportunities for individuals in protected groups. Now, the law on positive action allows organisations to take proportionate measures within the workplace to overcome disadvantage, to meet specific needs, and to combat underrepresentation in the workplace. So, for example, positive action may be taken where an employer reasonably thinks that a protected group suffers a disadvantage related to that protected characteristic, or, for example, social or economic barriers to accessing employment, has needs that are different to those who do not share the protected characteristic. So, for example, those who perhaps English isn't their first language, or those that are unrepresented in the workplace. Now, organisations can take positive action. However, I think you do need to be very cautious if you are choosing to do this, and to be able to demonstrate that it was lawful for that action to be taken. Firstly, we need to be looking at whether there is evidence to show that underrepresentation is required. So have a look at making sure that you have that evidence in place. Make sure that any action you take is proportionate. Keep that positive action under review, and clear and careful communication to staff. So make sure that you should think carefully about ensuring that you are transparent as possible, and the reasoning and the basis for any positive action that's being taken. So in terms of kind of positive action that's happening that we've seen recently, so for example, Centrica has stated it plans to recruit 1,000 apprentices over the next 2 years, with the ambition that 50% of these will be women. They've identified that women make up only 8% of its field workforce and are acutely aware that it needs to improve gender diversity to better reflect the customers it serves. Centrica has launched targeted recruitment campaign to help achieve this target. So again, it's just something worth considering. So if I can move on to the next slide. I'm sure you are all sick to death of the C word, but we just wanted to cover a couple of points. Obviously, the seminar that we did a couple of weeks ago, we had lots of attendees, lots of questions. So just wanted to give a bit of an update in terms of where we are now. Firstly, you will have all seen from the budget that the furlough scheme has been extended until the end of September. So this is expected to pay 10% towards the hours that staff do not work in July. Employers will be expected to contribute 10% towards the hours staff don't work in July, increasing to 20% in August and September as the economy opens. So again, that's just something to look out for. We're also really moving forward with the vaccination process, which we'd had already started when we did the last webinar, but we're now up to close to 25 million people in the UK having received at least one dose of the vaccine, which is fantastic. And one of the key issues we discussed at the last webinar was around whether employers can oblige employees to have the vaccine and dismiss them for failing to follow a reasonable management instruction if they refuse. Now, our view was that in most cases they could not, but the nature of some workplaces, such as those on the frontline healthcare or care homes for the elderly, may mean that vaccination as a precondition of work in some roles could potentially be justified on health and safety grounds. However, I think it still needs to come with a shining beacon of warning and say that we're still very, very unclear in terms of the government's position regarding vaccinations as a precondition to employment. There was some suggestion that could potentially be fair in some scenarios, but we're not really any further forward with understanding the kind of basis for that. So I think the key really is to look at what you as business can do to support and encourage employers to have the vaccination without it being a requirement, and certainly that is that is what the ACAS guidance recommends. So, for example, offering pay timed off to attend vaccination appointments. Previously, the ACAS guidance had acknowledged that it may be necessary to make vaccination mandatory where it is necessary for somebody to do their job. So, for example, if somebody is required to undertake overseas travel as part of their role. However, the ACAS guidance was updated on the 25th of February, and that section has now been removed. So again, we're very unclear as to what approach is going to be recommended in respect of that, and I think it is probably a case of wait and see. And I have no doubt that in the next 12 months or so we will have cases where individuals have been dismissed on the back of refusing the vaccine. So we'll need to see what the tribunal's approach in respect of that is. One of the things we are seeing with a number of businesses that we're advising at the moment is introducing a vaccination policy. And I suppose if this is something that your business is considering, it's worth just thinking about kind of how that consultation is going to happen. If you have trade union recognition or staff associations in place, it would be a good idea to have the conversations with those bodies before anything is put in place. How are you going to communicate that with the wider workforce? Data protection obligations in terms of processing the data, of understanding who's had vaccination and who hasn't, and how that data will be used. have a look at how the policy can be used to reduce the risk of potential workplace conflict between those employees that are vaccinated and those that aren't, and in which kind of scenario that policy will be reviewed. So, for example, when private vaccination becomes a possibility, it may be at that point that it's necessary to consider it. The vaccination should also have a look at the purpose and benefits of the vaccination. So again, one of the key points that ACAS has highlighted is making sure that staff are directed to information which is recommended by Public Health England, so that there is that kind of clear, consistent information that staff are being directed to, ensuring that it's set out clearly any pay arrangements. So again, like I say, what is the process for staff having vaccinations? Will that time off be paid? And then, like I say, finally looking at data protection and privacy issues, so making sure that that is covered off and everybody knows where they stand in respect of that. So that's all I had in respect of the webinar. I think we have a couple of questions. Do you want to go first, Fiona, or do you want me to?
Yeah, no, I'll go first. So we've had one question, just going back to harassment, about investigating allegations of harassment raised in a resignation letter and how practically to deal with that. And I have had instances where allegations of harassment have been raised in a resignation letter. I've had instances where maybe the alleged harasser has left our employment as well, and the employer is then left thinking, what do I do now? Do I still have an obligation? And yes, in either situation, I would suggest you investigate it as best you can with what you have. It may be that the person who's resigned, speak to them about, would they put the allegations in writing? Can you get some more detail about it? There may be reservation on their part, but obviously you as an employer have an obligation to the wider workforce. So I think encouraging that person, if ultimately you can only go on the basis of what they've told you, then you will have to investigate on that basis by speaking with relevant people to ascertain what happened. But you need to see if there's a wider issue within the workforce. And I think I have seen cases where action hasn't been taken and then the employer's been criticised. Conversely, if the harasser has left our employment, again, I would still be investigating that. Can you speak to the alleged harasser? Maybe not, but there may well be people within the workforce who we can go and speak to say, look, there's allegations of this nature, that this happened. You were alleged to have been a witness. What did you see? And even though that alleged harasser has gone, you may think, well, what am I going to put in place as a result of that? Again, it's not just as simple as that. There may be a wider spread issue. Until you start that investigation process, you don't necessarily know. And even if that person has left our employment, there still may be learnings that we can take away from the situation. So think about all those sorts of issues as well. Do you want to take the next one?
Yeah. So again, it's something that I think comes up relatively regularly. So what do we do if we have a reluctant employee who does not want to make a formal complaint about sexual harassment in the workplace? Again, I think that's something that comes up quite often. I think from an individual perspective, obviously it takes a lot to raise such a complaint, and it may be that once they start having those discussions, then the individual may not feel that they are strong enough to move it forward, or they may have a belief that it's not going to be dealt with seriously. And from the business's perspective, I think they are going to be worried about inconsistency if there is a future more serious incident, particularly if you are a business that are looking to kind of change culture and take a much firmer line with harassment. So I think the first thing to do is to establish if the employee can be spoken to and reassured about raising a formal complaint. So, for example, can they be reassured by obviously highlighting the fact that anything said will be dealt with confidentially, and the circle of individuals who will be aware of the allegations will be very small. Or likewise, although there are sometimes issues with this, can there be an offer of anonymity, so that they may feel more, they may feel braver in terms of coming forward if they are anonymous. If the answer to that is still no, then I think you're then left with a very difficult situation where you may not reach that threshold of being able to establish enough to move it forward to a disciplinary hearing. So whilst I think it is going to be appropriate to investigate it and to see whether there is anything else that can be considered, whether there is anybody else in the workplace, perhaps the kind of wider team to ensure that there are not any other issues there, and perhaps any other employees that are more willing to speak up. If the answer to that is no, and perhaps the only information you have is about this one individual who is refusing to make a formal complaint, then it may be that you do have some difficulties in moving that forward from a disciplinary perspective. But I think certainly that's not the end of the story. And I think from a business's perspective, it may be that is an appropriate time to look at training, reigniting the importance of policies and procedures so that everybody understands what is and is not appropriate, and to make sure that employees understand the process that they need to go through if they do have concerns relating to sexual harassment.
I think, Emma, we've only got a few minutes left, and I'm conscious as well that we need to do a poll. So I may well leave it there on the questions. Do you agree, or do you want to squeeze another one in?
No, that's fine. We can go back separately if there's anything else, can't we?
Yeah, exactly. So we'll do a poll in a minute, but I think our key takeaway from this session is, do make sure, in light of these recent cases, the new ways of working, do make sure that your training and your policies are up to date. It's not simply a tick box exercise. If in the event you do have these sorts of issues being raised, Emma and I do undertake audits. We can do a free audit of your policies and training if you need a steer. And we're also going to be holding some focus groups, because we're certainly finding loads of queries are coming in on this. So we just had a quick poll for you before you go. Tom, I don't know if you can put that up on screen. So we've got these small focus groups which are with other HR professionals on diversity and inclusion, how to refresh your policies, and a separate one on latest COVID developments. If you wouldn't mind indicating if you would like to be involved in either of those sessions, or perhaps both, please let us know. We've got a few seconds remaining on that. And then we will get back to those who've indicated in terms of when they'll take place. And I think, unless Emma tells me otherwise, I don't know, Emma, if you had anything to cover off. If not, I think, Verinda, did you want to close?
Hi, yes, just to say thank you to you both once again. That was really, really interesting. Lots of useful insights there and hints and tips as well. So look forward to the next one, guys. I'll sure to be sending an email out in the next few weeks in terms of what the next topic's going to be. And as usual, I'm sure it's going to be well attended. And thank you for all of you who've said what kind of focus groups you'll be interested in. I think that's a new way forward. Might be quite interesting to see how those develop. So yeah, just from me, thank you everybody, and I'll be in touch with the next topic.
Thanks very much.
Thank you.